Hey everybody, John Skiba here. And if you have been sued by one of your credit cards recently, you're probably feeling a lot of stress. Your mind's going to the worst place and you're not sure how to deal with it. I promise you this, you've come to the right place. If you watch this video and spend the next 5 minutes or so with me, I promise I'll offer some strategies and tips that'll put your mind at ease and help you put together a plan on how to deal with this debt collection lawsuit. But if this is your first time here to my YouTube channel, go ahead and click subscribe, check on that little bell. That way you'll be notified each and every week when I put out a new video that can help you deal with your serious debt problem. All right, let's talk about debt collection lawsuits, particularly those brought by credit card companies. When you get sued by a debt collector, they come by, the process server, the sheriff, the constable, whatever they do in your state. They bring by that complaint, they bring by the summons, and immediately, like I say, your mind goes to the worst place. You start thinking you're going to go to jail over this, that they're going to garnish your pay, they're going to take all the money out of your checking account, or they're going to lien your home. You go to all these terrible places, and I can tell you this, most of these cases can be resolved with a little bit of planning. And so, and not only that, debtors' prisons were abolished back in the 1800s. You're not going to jail over this credit card lawsuit. But they can do things like garnish your wages, garnish your bank account. They can even lien your home in some states if you allow them to get a judgment against you. So you want to avoid allowing them to get a judgment. The number one thing you need to do to avoid a judgment is to file a written answer to the lawsuit. Did you know over 95% of debt collection lawsuits end in a default judgment? The reason why that happens is because people don't respond to the complaint. When you have the complaint and the summons, you take a look at it, there's usually a deadline that's put on there. Like in Arizona, you have 20 days to respond to it. Other states, it's 30 days. But you have to file a written response to the allegations in the complaint, otherwise you could end up with a default against you. I have a lot of other videos on my YouTube channel. You can do a quick search on how to draft an answer to a debt collection lawsuit. It's not super hard. You can file that response. That generally will buy you a lot of time. So let's talk about the debt collection lawsuits themselves. The first thing I do when I hear someone's been sued by one of their credit card companies is I kind of break it up into two different categories. I ask, did you get sued by the original creditor? Is Chase Bank suing you, Bank of America? Who is it who's the plaintiff who actually brought the suit? And note, I'm not talking about the lawyer. Sometimes there's a misunderstanding that the lawyer who represents the creditor is the one who actually owns the debt, or they're wanting to be the one who is suing you. They're generally just hired attorneys. Just like, if you have an injury or something and you hire a lawyer, these banks go out and hire lawyers too to file the lawsuits. So you look in the plaintiff section of the caption, that very top part of the lawsuit, to see who it is who's actually suing you. If it's the original creditor, I generally will recommend people take a settlement strategy to their case. That still means you can file an answer to avoid any kind of default judgment, but generally if you go to trial against the original creditor, unless you're dealing with something like identity theft, it's likely they're going to have the witnesses and the documents and all they need to be able to establish that you owe them money. And so not only that, if you go to trial and you lose against the original creditor, in many states they can actually add on the attorney's fees and court costs and everything else, and all of a sudden that $2,000 lawsuit is turned into like a $5,000 or $6,000 judgment. So you want to be real careful about taking cases to trial that you don't have any real chance of prevailing on. With original creditor lawsuits, that's why I generally recommend people take a settlement approach. The settlement approach is that you're actively negotiating with the attorney who's representing the plaintiff, trying to come up with some middle ground that you can pay to get the case resolved. Now, if you've been sued by a junk debt buyer, if you watch my YouTube videos a lot, you'll know we talk a lot about debt buyers like Portfolio Recovery, Midland Funding, Unifund, Cavalry SPV, Unifund, and all the other people who are out there. Those types of lawsuits are quite a bit different because the creditor is alleging, the plaintiff in that case is alleging that they purchased the debt from the original creditor, usually for pennies on the dollar. There's even some debt buyers out there that paid less than a cent on the dollar for the accounts that they purchase. Now, their situation is quite a bit different because not only do they have to prove you had the account with the original creditor, they have to prove that the account, your account, came to them, and then they have to be able to prove the exact dollar amount owed and how they calculated those damages. So those types of cases, though, they often don't have the witnesses and the documents that they need to be able to establish their case. The reason is they pay very little, they get very little in return from the original creditor. They may get a couple monthly statements, a very generic bill of sale. And sometimes they'll have a witness who's from their own company. I can tell you I've been doing this for 20 years. I've done over 400 trials against debt buyers. And I don't believe once, thinking back here, I don't believe once that I have seen the original creditor's, a debt buyer bring in a witness from the original creditor. It just doesn't happen. And the reason is because it costs money to bring those in. They're trying to operate this at a very thin margins and just get a judgment very quickly so then they can start the wage garnishment. So if you have been, if you've been sued by a junk debt buyer, again, still file the answer. But that's a case where you may want to push it a little. You may want to do a little bit of what's called written discovery and request documents from them. You may want to push that case towards a trial and put them and hold them to their proof. Make them prove their case to prove, again, that you had the account, that it was transferred to them, and how they calculated the amount owed, because they struggle to do that. Whereas if it's an original creditor, they usually can do that pretty easily. That's why I recommend a settlement approach to that one, and maybe contesting it / settlement to the debt buyer type cases. Now, there is one other third option I generally give people on these lawsuits. There is the option of bankruptcy. Now, I know that nobody wants to file bankruptcy as their first option, but I can tell you that if you get sued by a $2,000 junk debt buyer lawsuit, yeah, fight that or settle it. But if that's just the tip of the iceberg and you're dealing with multiple accounts that are delinquent or multiple lawsuits, Chapter 7 bankruptcy in most cases will wipe those debts out completely, stop the collections, and allow you really just to move on with life and start over and get that fresh start that they talk about with the bankruptcy. So those are a few options on how to deal with these things. Again, I know your mind's probably going to really tough places when it comes to these things, but these can be resolved. At the end of the day, the creditor wants money, and if you're trying to offer a settlement, you'll be able to come to some type of middle ground on it. Or if a bankruptcy is a better option, like I said, then you have the power, the full power of the federal government, of a federal law on your side to be able to wipe out those debts and move forward. But putting a plan together is going to be the thing that alleviates that stress. You're probably up at night stressing about this. You don't need to be. Just put a plan together, and that'll help you to take that next step. And again, the most pivotal step of all is getting the answer filed. I have a tutorial that will show you how to do that. I'll put a link down in the notes here of the video so you can take a look at that. That can help you if you're just trying to put together that initial step to decide whether you're going to be pursuing trial or whether you're going to try to settle it. So I hope that helps you today. I hope that puts your mind a little bit more at ease as far as dealing with these debt collection lawsuits. You can deal with it. You can do it. I know you can. But I appreciate you watching today. And if you haven't subscribed already, please do. Please subscribe. We've been growing the channel, by leaps and bounds lately. I appreciate all the feedback and the support of the channel, and I hope it's helpful. Thanks for watching today.